Hello and welcome to Property Money Trees, Maximising Property Values, the once a month show where I break down the steps of how to recognise, enhance, and then extract the values in property in order to create wealth. Would you like to find out how you can benefit from the steps of maximising property values? This is even if you don't own a property yet or have a deposit. If that's a yes, then you're in the right place to find out. My name is Patricia Faber, and although many know me for my work as a solicitor, on this show you will be getting the benefit of my 30 plus years worth of experience of maximising property values, experience which has given me a net worth in millions. So who might benefit from listening to this show? Literally anyone with an interest in creating property wealth. Hello and welcome back. Well, I bet you my regulars are wondering, they're thinking, what is this topic all about? Hosea 4:6? What has that got to do with property? People who know the Bible will be thinking, oh my goodness, we thought this was a property podcast, not one about the Bible. But people, what does Hosea 4:6 actually say? It says, my people are destroyed for lack of knowledge. My people are destroyed for lack of knowledge. Now that, clearly was to do with the people of Israel. However, the same principle can apply to our property businesses. The lack of knowledge can destroy a business right in its tracks. Is that what we want to happen to our businesses? Obviously not. So we need to get ourselves educated. We need to get people who know, who can tell us what, the relevant things are about what we're doing, and then we can make the right decisions for our businesses. Yet we do not want to be a Hosea 4:6 person, someone who is destroyed for lack of knowledge, someone who allows their business to be destroyed because they are not educated. They do not have the relevant knowledge. Anyway, that is what this series is going to be about. It's going to be about the importance of the right knowledge so that we can make the right decisions for our businesses. And this particular episode, so I'm going to do a series of them. If you've been listening to me, you will know that I love doing series. Anyway, this particular one is going to be about auction purchases when we buy leases. And let me just try and highlight the danger of doing that without the right knowledge, especially if you happen to be unfortunate and you happen to go and bid and win one of those leases that nobody really wants, but you've bought it because you didn't know what you ought to have known, what you would have known if you'd gone and paid for a solicitor to actually advise you on what you were going to bid on in the auction. So let me start from the very beginning. What is a lease? So a lease is a contract between the owner of the land and somebody who wants to use that land, but not permanently, so they only get it for a period of time. And the parties will then decide on their relationship through the various rights and obligations that they put into the lease. So you will have the landlord will grant the right to live in the property. It could be land that's leased. It could be a house that is leased. But usually it's flats because where you've got flats, you must have, the people agreeing to do certain things. So they might share utilities, or they might share communal areas. And if there isn't a lease that's going to say, well, do you know, this is how the communal areas are going to be dealt with, you might have, say, like one leaseholder saying, well, actually, I want the communal area for, for myself, or I'm not going to allow you to walk past my door, or something else that might just be as unreasonable. However, the lease will provide, the various clauses that will make sure that none of that can happen, and that each leaseholder can actually enjoy their property without interference from other leaseholders. So the lease document, the lease contract, is actually very, very important. So yes, so you have the freeholder, the owner of the land, and you have the leaseholder, the person who's actually going to be using the land. Like I said, most people who are going to be involved in leasehold properties are going to be dealing with flats. Anyone who knows me knows that I love flats, absolutely love them. So this is not anything against flats. It's just what it is. As long as you're properly advised, so you have the right information, then you will be absolutely fine and okay. Now, so you have your freeholder, you have your leaseholder. Now, for contracts to be binding, there has to be consideration. Now, again, this is a legal term, and many, 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 many years ago, the courts decided that consideration just had to be anything that was of value. Now, it doesn't have to be high value. It just has to be of some value that you don't already own. Now, for lots of contracts, the consideration is the mutual obligations in the contract. However, the more important the contract, you also want for there to be no doubt whatsoever that consideration has been paid or is being paid. And that is why you would have, some contracts will say, for the sum of £1. So £1 is nothing. Most people can afford £1, particularly when you look at the sums in the contract itself. £1 is not a problem. But most people in property will also be familiar with the term peppercorn, a peppercorn rent. And a peppercorn, if you think about it, think about maybe going to the supermarket and buying a box of black peppers. And each peppercorn is what is being referred to as the consideration for the lease in question. So if you extend your lease, and I have spoken about that, I've done podcasts on that. The statutory process, if you go through, what the Section 42 procedure, you will be entitled to extend your lease by 90 years at a peppercorn rent. So that's where the peppercorn comes into it. Now, again, people are saying, don't go for the peppercorn. Do you know what? It really exhausts me. They're saying don't go for the peppercorn, because if you go for a peppercorn, there are some lenders now who are saying they don't want peppercorn leases because there's no incentive for the landlord to carry on doing what they're doing, and they may just walk away. Now that to me is absolute nonsense, because there may not be a financial incentive for the landlord to carry on doing what they're doing. However, the rights and the duties that the landlord has entered into with other leaseholders means that they're not going to be walking away, especially if they have other assets. Because if a landlord doesn't fulfill the duties of that they say they're going to carry out in the lease, then they can be sued, and the courts can award the leaseholders damages, especially if they have been damaged, if they've suffered any loss due to the landlord's inaction or the landlord's failure to carry out the landlord's duties, then the courts can award damages against the landlord. So landlords they have every incentive to carry out their duties anyway. That is just by the by. So we have that situation. We've got the landlord, we've got the tenant, so we've got the freeholder and the leaseholder. Sorry, I'm going into legal jargon here, landlord and tenant. So we've got the freeholder, we've got the leaseholder, we've got the contract between them, and we have so when the contract is first done, which if it's a new build block of flats, it will be when those flats are first being sold, when they're first being offered onto the market for sale. And it's the same with conversions. So if you have a small block of converted flats, if they are being offered up for sale, then leases will be created for each of those flats. And you also have, people who convert, houses into flats, and they don't, create leases for the flats because they don't intend to actually sell, the flats at that point in time. And just to actually just drop it in there, you can't, if you own the freehold, say, of a building, and then you convert it into flats, you can't just create leases for the flats, for yourself, because the law doesn't allow for the same person to own both the freehold and the leasehold in a property. What will happen is the leasehold will collapse back into the freehold. So the effect of it will be like you hadn't created the leaseholds. There are ways that people deal with it when they need to create the leaseholds. And if you are in this situation, you want to get proper legal advice and you want to get proper tax advice as well. The first creation of a lease is the grant of a lease. So when the subsequent sales of the lease is actually called an assignment of the lease. So they are two slightly different things. So the grant is the very, very first one, and then the subsequent ones where, the first leaseholder sells on to the next leaseholder, and so on and so forth. Those are called assignments. So when the lease is being granted, it could be for any number of years. It could be for 21 years, it could be for 50 years, it could be for 99 years, it could be for 900 years. But most leases are granted for, today, we are in 2021, they're normally granted for about 125 years. So you've got your 125-year lease, you've got, as I said, the lease, which is the contract between the parties, the lease. So this is the 125 years or the 25 years or the 21 years or the 900 years. Is the length of time that the freeholder is saying the leaseholder can use that property, subject to the terms and conditions of the lease. So that is called the term. It's the length of period, and it will usually be stipulated along the lines of this lease is being granted for 125 years from the first day of January 2021, or whatever date it is that the parties agree on, or the leasehold or the freeholder wants. That is how the term is normally sort of like set out. Then, to make sure and to doubly make sure that there is consideration between the parties for the lease, you then have the situation of ground rent, which is which was supposed to be a nominal sum of money to be paid to the freeholder by the leaseholder every year. So originally, these amounts would have been like £10 a year, sometimes for the whole length of the lease, and sometimes going up every 25 or 33 years. So initial leases used to be for 99 years, so you'd have maybe £10 for the first 33 years, and then you'd have it going up to maybe £20 for the next 33 years, and then finishing off at maybe £50 for the rest of the term. And you will find like different ground rent clauses for different leases, and so it none of that is really important. What is important is that you are aware of how much ground rent you are going to have to pay under that lease. Now, why is this important? It's important because of the Housing Act of 1988. Now, Section 1 of the Housing Act provides for what is going to be an assured tenancy. And within the Housing Act, assured tenancies can be reclaimed, or, the underlying property for assured tenancies can be reclaimed by landlords under the procedures which mandates the courts to give possession to them. Now, most of us are going to be familiar as landlords of the Section 21 procedure, as well as the Section 8 procedure. So Section 21 it's called a no-fault evictions procedure, which again the government is saying it wants to look into and perhaps ban. And we also should be aware, if we are landlords, of the Section 8 procedure. Now, Section 8 contains mandatory grounds for possession. If you go to court and you can prove your Section 8 grounds, the court must give possession. Must. Now, normally with long leaseholds, if the tenant didn't pay the rent and then after 21 days, the landlord could actually the freeholder. It's the same thing. I'm just so used to calling the freeholder a landlord. The freeholder could actually start proceedings in court to take back the lease, and without paying, it's called forfeiture. Now, if the freeholder got to court, what the judges would normally say is, no, that is not fair. So you, leaseholder, you've been a bit naughty not paying your ground rent. Go pay your ground rent and or service charges, whatever it might be that, the freeholder is claiming forfeiture for. Pay it all up, and then you pay the costs of this action. And if you can't pay it, you're the person who's loaned you money, your mortgage company will pay it for you. And if they don't, then the freeholder can then have the property. So normally you would find that those monies would be found and they would be paid, if not by the leaseholder, then by the mortgage company, because the value of that property to them and the value of their loan is going to be a lot more than the ground rent and the service charges or whatever else that hasn't been paid. So that worked brilliantly for everyone until the Housing Act of 1988, which then could make some long leaseholds assured tenancies. Now, which long leaseholds can become assured tenancies? They are leases where the ground rents can be, so they don't have to be at the moment, but they can in the future be £250 a year or more. And that figure becomes £1,000 if you're in Greater London. So if you're not within Greater London and your lease can charge you ground rents of £250 or more pounds per annum, then you could be holding an assured tenancy. Your lease could be that, and that is problematic for lenders, because that literally just diminishes the value of their lending, of their security. It can become nothing. And also, under the Housing Act, the freeholder doesn't have to tell the mortgage company what they're doing. They don't have to. They just have to wait for that money to be owing, and then, use whatever procedure they want to use to get that property back. Now, if you're dealing with a very unscrupulous freeholder, you can see how they would want to do that. Lenders do not want to take that chance, and who can blame them? So quite a number of lenders will not lend on such properties. So if your property outside of Greater London can incur ground rents of £250 per year or more, boom, you've got problems. And if you're within Greater London and that figure can go up to £1,000 or more, again, it's a problem. They're not interested. So there may well still be some people who can be or will be interested and will be willing to lend on, such properties, but they are very few and far between these days. So I have picked an auction purchase as being the one that could entrap people who don't know what they're doing. And the reason for doing this is it's plain. It's quite straightforward. If you're buying on the open market, then your solicitor is going to let the lender know, or if the same solicitor is acting for both of you, and if you've got separate solicitors, the lender's solicitor is going to let the lender know that you've got one of those leases, and the lender's either going to say, get the ground rent clause changed, or they might just say, we're not interested, we're not going to lend on it. And okay, fine, you might have paid, your survey fees, you might have incurred some legal fees, but all in all, your losses will be limited to maybe about £2,000 or similar. If, on the other hand, you've heard about people buying leases, could be short leases, could be whatever leases, and you're thinking, yeah, oh, absolutely fantastic. I've learned everything that I need to know. I've been in clubhouse rooms. I've listened to podcasts. I've watched YouTube videos. Yep. Leases. That's the way to go. That's the way I'm going. But you don't know about this ground rent problem, and you see something in an auction because it won't sell on the open market, it can't sell on the open market, and you go and you bid for it, and you probably even bid for it at what a good lease would cost on the open market, and you get it and you're really excited because the hammer goes down on your bid and you are the potential owner of this property. Now, you will then have to pay a 10% deposit, and you'll have to pay the auctioneers. Usually it's £1,000 or £1,500, depending on the value of the property itself, blah, blah, blah. And then what happens? You might be able to get a bridger to lend you the rest of the purchase funds. That is, if you're not buying it for cash. But even bridgers want to know that you have a good exit strategy. So they will ask you, what is your exit? What strategy are you looking to implement in order to pay us our money back? So if you say, I'm going to be selling this to somebody on the open market, they will know that that's not going to happen, not with the lease that you have. If you say, oh, I'm going to be remortgaging this or refinancing this to a term lender, they will know that your choices are going to be severely restricted. So again, they might not be happy to actually lend to you. So your problems might actually start immediately. But what can you do to make sure that you are not that Hosea chapter 4 verse 6 person? That you are not the person who is destroyed for lack of knowledge. In the situation that I'm talking about, you would be the person who would pay a solicitor, a practicing conveyancer, somebody with the expertise to advise you on the property that you're thinking of buying through an auction. Okay, fine, they may charge you £150, but wouldn't you rather lose £150 than lose thousands and thousands of pounds? Because remember, you're going to have to pay your 10%. You've probably paid your 10% before you were allowed to bid, or you'd have paid some amount of money anyway, especially with online auctions and things. You have to pay an amount of money to the auctioneer before you are actually allowed to bid. You're going to be paying your how much is the property worth? If you're buying it in London, chances are it's worth about £200,000 or something. That's £20,000. Then if you don't complete and the owner of the lease then sells it for less than what you agreed to pay for it, and your deposit doesn't plug the gap, they can still come and sue you for the difference. So honestly, this is the first example of people who might do something that is detrimental to their financial well-being, and only because they didn't know, because they didn't pay the person who did know to advise them. So please do not be that Hosea chapter 4 verse 6 person. If you are buying leases in auctions, go pay someone to advise you on the legal pack. That's if you're not, if you don't have the skills to actually read and understand the packs yourself. Ground rents are very, very important. Do not buy a lease that is unmortgageable, because unless you want to just kind of hold on to it and see what you can do with it, initially it's going to be problematic for you. Now, there are ways to actually get out of these leases. One, you can negotiate to remove that clause. It will cost you, but better than, not doing anything at all. Or if you're already in that situation, or you can afford to do so before you get your mortgage, then what you might want to do is get the seller to exercise their statutory rights of extension. Doesn't matter the length of the lease. It could have 200 years remaining on, the lease and the term. You still want to extend the lease, because once you extend the lease, once you instigate the statutory extension procedure under section 42, you will be able to extend the lease by 90 years. But in addition, the ground rent will then go down to a peppercorn. That is what the statute provides. So again, you can do it like that. Another way is to actually get an indemnity policy that, Armageddon is not actually going to happen. But most lenders are not, they don't like that. So that isn't really an option. There are different ways in which you can get around this. But when you are, say, for instance, buying at an auction, you've got 20 days within which to complete and you need funding. The way to kind of get yourself out of these bad leases and not get those routes are not going to be open to you. So, the practical chances of you holding on to your deposit are going to be severely diminished. So honestly, get yourself educated, get yourself the knowledge. If you don't have it, buy it. Go to a professional person who will give you the proper advice that you need so that you can make the right decision for you and you can continue to create generational wealth and not deplete whatever wealth you are creating. Anyway, I hope you've enjoyed this, and I hope to see you next month. And if you've enjoyed it, like I say, honestly, please do rate and review these podcasts. But even if you can't rate and review, and to rate and review, all you need to do, especially if you are listening to Apple Podcasts, because most of my listeners do actually listen through the Apple Podcasts, is literally just scroll down to the bottom of the page and there will be a link there that you can click on in order to review what you are listening to. And if you can't do that, people who drop me lines, who send me like messages on Clubhouse, who send me again like direct messages on Instagram, telling me how the podcasts have actually changed their investment journey. Honestly, again, to you people, thank you very much, because it is so encouraging just to know that, what little I am doing is actually making an impact to some people's, business journeys, which is why I started doing these podcasts. So again, I'm literally just going to say, thank you to everyone who's doing it. And if you haven't done one already, please honestly do it one way or another, Clubhouse or Instagram or email, but preferably on the podcast platforms, because that will just help other people find the podcast and also get to start to listen to them and get the same benefits that you are getting. Anyway, hope to see you next month. Yep, take care.